Mr. Weiss.
Yes, Your Honor. This matter has been adjourned a couple of times. The balance owing is basically stemming from pet fees and a pet deposit for an animal that Ms. Bell had.
We dive straight into a stormy legal showdown. Judge Simpson is on the bench, and the stakes revolve around something that might sound trivial at first: pet fees and an emotional support animal. But don't underestimate this. Emotional support animals, or ESAs, sit in a legal gray zone that landlords and tenants clash over constantly. Right here we've got Miss Bell, who once had a pit bull approved as her ESA back in 2019, with proper doctor certification. No pet fee, no deposit, everything looked solid. Fast forward, the dog allegedly bites a tenant, gets removed, and she later replaces it with a chihuahua. Seems straightforward, not even close. Now the landlord wants recertification of her need for an ESA. That might sound routine, but legally it's a hornet's nest. Is the landlord allowed to demand new proof years later? Judge Simpson clearly smells something inconsistent. Viewers lock in. This case is about to unravel years of housing rights and expose serious contradictions in landlord policy.
The question that's presented is the application of ESA. Back in 2019, Ms. Bell applied for an ESA for a dog. I believe it was a pit bull. She had a letter from her doctor indicating the need for the support animal, and it was granted. At that point in time, she did not pay a pet fee or a pet deposit. Subsequently, I believe in February of 2023, she had to remove the support animal because it was a pit bull and apparently had bitten one of the tenants. That was in February. She replaced the animal, and then in October of 23, we requested that she certify the new animal, which I believe is Pied Chihuahua. And
Well, let me ask this, because what was, I remember the issue, but the certification for the animal, however one wants to put that. Well, let me put it this way. Does the complex certify the animal?
the complex asked that she certification that she of her needs for the support animal, which in 2019 she did provide for us. We asked starting in October when she got the new animal, we asked that she recertify herself that she had a continuous need for that support animal.
Okay, and again, that I guess brings me to the next point. If nothing had happened with the pit bull, she wouldn't have had to recertify anything.
Judge Simpson zeroes in on the heart of the issue. The only reason this whole fight exists is because the pit bull was removed. If that dog had stayed, no one would have demanded new paperwork. This is powerful because it exposes selective enforcement. In law, consistency matters. If landlords treat one tenant differently from another, or even treat the same tenant differently at different times without clear rules, it opens the door to claims of discrimination. Fair housing laws were designed to prevent landlords from moving the goalposts mid-game. Ask yourself, should a person's need for an ESA suddenly expire just because the specific animal changed? Imagine needing glasses. Your prescription doesn't vanish if you swap out frames. Judge Simpson is pressing Weiss to explain why the timing makes sense, but you can hear the cracks forming.
Well, we take the position that we could have asked her to certify, but we didn't. The fact that she had the replacement animal brought it to our attention. Does Ms. Bell still need a support animal? If so, we ask that she be recertified. We asked, and I have if I can present to the court, if I may approach Your Honor.
What are those? And
This is a thread of emails between Group 5, Group 5's attorneys who was handling the case then, and Nikki Green from Fair Housing, talking about the pet situation. And Nikki Green basically said she was going to follow up with her doctor, I think Dr. McAvoy, to see if we can get the certification. According to our information, Dr. McAvoy refused to do the certification. We asked that.
Here's where things turn messy. The landlord's attorney admits they contacted multiple doctors to recertify Miss Bell's need for an ESA, but one doctor outright refused. That's huge. Why? Because courts don't like fishing expeditions. When a landlord starts digging into someone's medical need without clear authority, it looks invasive, possibly even discriminatory. Judge Simpson pounces on this, pointing out that the certification in 2019 was about Bell's need, not about a particular dog. That's a critical legal distinction. Emotional support animals aren't like driver's licenses that expire. Once your need is certified, it's usually presumed ongoing unless challenged with strong evidence. So why chase new documents years later? From the outside, it sounds like the landlord was hoping to catch Bell in non-compliance. But that kind of gotcha approach rarely sits well in court.
She possibly
but was that
another
the previous doctor?
Hmm?
Okay, but here's my issue with this. When she did that in 2019, she's not certifying the animal.
Correct. She's certifying her need for an animal.
Right. So what would lead the complex to think that changed?
Well,
Because and the reason I'm asking that is because based upon at least what's been represented to the court, the only thing that happened is the removal of the animal.
that brought it to the attention of management that does she still need a support animal? And that's why we request a certification.
Why would that raise the issue?
Well, I believe there's a difference between an ESA and a service dog. A service dog, if you're blind or
Right.
handicapped, you apply for a service dog. That's a different type of certification. And at that point in time, if it's granted, basically it's for life. Support animal is different.
The attorney tries to draw a line between service animals and emotional support animals. And yes, legally there is a difference. Service dogs are highly trained, task-specific, and protected under the ADA for life. Emotional support animals, by contrast, don't need training and are covered under fair housing rules, not the ADA. But here's the flaw. Nothing in fair housing law says a tenant's emotional needs have an expiration date. Judge Simpson hears Weiss, implying ESAs are somehow temporary by default. But when pressed, Weiss can't cite any statute. This is where sharp legal minds know, if the law doesn't explicitly give landlords that power, courts are unlikely to invent it. You can sense the judge's frustration building. It's almost as if Weiss is trying to stretch the law past its breaking point. That's always risky in a courtroom with a judge like Simpson.
It's like,
Well, what explains to the tenant that it's different? I mean, because from what I'm hearing, and correct me if I'm wrong, in 2019 to 2020, in 2020, the dog is still there and she doesn't have to do anything. The dog just continues there. 2020 to 21, same thing. 2021 to 2022, same thing. So I'm looking at a 3-year period where she has to do nothing. She has this dog.
We didn't
Then
raise
the-
that issue at that point in time, but
Why, though? I mean, what makes not raising the issue at that time as opposed to raising it later on? What's the distinction
well,
if you're not certifying the animal?
I believe that in a situation that the complex has the right, and there's nothing in the law either way, that we have the right to certify, recertify, or we don't have the right to recertify. So it brought us to the attention, does Miss Bell still need certification? And it's a simple process. All she had to do is go to the doctor.
But I get that that's the process that the landlord wants her to enter into.
Correct.
The problem that I'm having with this is why was the request made at that time as opposed to being made at every 6 months, every year, every whatever?
Well, the dog was, the pit bull was removed in February of 23. We waited 8 months. She got a new dog. We waited 8 months until October of 23 in order to give her some time to get the certification. At that point in time, we formally requested it, and that's when we started
Okay, but when
assessing.
did the new dog come in?
Notice the timeline problem. The pit bull leaves in early 2022. The Chihuahua arrives December 2022, but the landlord doesn't ask for new certification until October 2023, almost a full year later. That gap is deadly for their argument. If they truly believed recertification was urgent, why wait? Courts often apply a reasonableness standard. Was the landlord's action timely, consistent, and fair? Here it feels arbitrary. Judge Simpson points this out. Why demand proof so late if the issue was supposedly so important? This inconsistency undercuts the landlord's credibility. For viewers, it's a reminder in legal disputes. Timing is everything. Waiting too long can make your claim look like an afterthought or retaliation rather than a legitimate concern. Audience poll: should landlords have the right to periodically recertify ESA needs, or does that cross the line into harassment?
Excuse me.
When was the new dog?
I can tell you all of that real quick because my mother doesn't even really sure of it. Faithful was moved out of the house in April of 22, not 23.
Okay,
She got
that's
home
fine.
in December of 22. You all got the wrong dates. I don't know
It
why.
doesn't, ma'am, I don't need that.
Okay.
If the dog got removed February, April,
Mhm.
when did the new dog show up?
December of 22. December of 22.
Yeah, it was 8 months after the old dog was removed.
And then when was the request made for the new?
In October of 23,
So,
I believe.
so was that the first request for the
For
ES?
recertification, yes. In October of 23.
So why did that happen then?
Why? Because at that point in time, we reviewed our records and we said, well, does Miss Bell still need the dog? And
So-
that's when we,
Whoa,
that's,
whoa. No. I'm just trying to sort this out. Because this doesn't make much sense to me. The pit bull gets removed February of April, whichever it is, of 2022. Right? The new animal comes in December of 2022. Right? And the request for this is effectively a year later, 10 months later,
correct.
by the landlord.
Yeah. Yeah, I understand what this court is struggling with, but if you take a look at, comparable laws like workers' comp, not social security or disability insurance, they have the right to review the continuing disability.
Weiss tries to rescue his case by comparing ESA recertification to disability reviews in Social Security or workers' comp, but Judge Simpson cuts through this analogy like a knife. Why? Because those programs are backed by clear statutes. Federal law explicitly authorizes periodic reviews for disability benefits. Landlords don't have that authority written anywhere. Not in leases, not in fair housing rules, not in ESA guidelines. Without a legal foundation, the analogy collapses. It's like comparing apples to court filings. It just doesn't hold up. Simpson's point is simple. Unless the lease specifically gives the landlord that right, they can't just invent it later. This exchange highlights a recurring theme in law. Landlords love to borrow concepts from other systems, but unless the legislature says so, courts won't enforce them.
Every so often, every 6 months.
But you're not reviewing her disability.
Yeah, by asking her for recertification, we're asking.
Where in the lease does it state you could do that? I mean, because
it doesn't.
That's the problem. The problem
we're dealing with also with the law, Your Honor. The law is unclear on it itself. The ESA fair housing, as it pertains to ESA, and I checked into it. There's no.
I get that. I understand the complexities or absence thereof. What I'm looking at the circumstances of this. So one thing that's very clear to me is, had the pit bull remained, there wouldn't have been a request.
Maybe.
Well, there wasn't. Right?
Yeah. But
pit bull gets removed, a new dog comes in, and when the new dog's there still is no request.
At that point in time, no. I
then think 10 months later, effectively, almost 11, really, I guess, depending on when in the month these things are occurring, 10 to 11 months later, there then is a request.
Correct.
And I'm trying to figure out, why was that request made?
It was brought to our attention that, does Miss Bell still need a support animal?
Brought to your attention by whom?
It was brought to our attention in the review of the record. A review of the record when we found out that she had the new dog, we asked that she recertify herself as a need for that support animal. And it's a simple, I understand the court, but it's a simple process. And according to the.
But why would you ask? That's my question. I'm not so much concerned about what the process is. I'm not concerned about what happened, didn't happen. Why would you ask?
It was a review of the records showing that she has a support animal. Does she need a support animal?
But hold on a second. When was the landlord aware of the new animal?
This is classic courtroom cross-examination, but delivered by the judge himself. Simpson drills down to the essential timeline. When exactly did the landlord know about the Chihuahua? The reason is simple. If you want to enforce a rule, you'd better prove you were aware of the issue at the right time. The attorney wavers, pointing to 2023 emails. But notice how weak that sounds compared to the concrete dates Bell's side provided. Courts look at credibility. Tenants who provide clear dates often come off more reliable than landlords who rely on vague records reviews. For viewers, here's the big takeaway. If a landlord delays action for months, it undermines their authority later. It's like finding a problem with rent in January, saying nothing until October, then claiming it was urgent. Judges don't buy that.
This is Kurt Herbeck. He's the.
I just need an answer.
October.
October of what?
October 23. That's when she was first charged, SB.
No, I'm not saying a charge. When does the landlord know she has this new animal?
I think it was sometime in 2023, according to the email threads I'm looking at. It was prior to.
It was several months after she removed the pit. She was observed with the Chihuahua, and that's when she was asked about it. She never came to
That was 11 months after.
Yeah, but we didn't know that she had the Chihuahua at that point in time.
Is there a policy regarding this at all with the landlord?
Is there a policy
A
with
written policy? What places the tenant on notice that this has to happen?
This is a devastating question from Simpson. Is there a policy? In law, policies are the backbone of enforcement. Without a written rule, actions appear arbitrary. Here, the Landlord's Council admits there's no reference to ESAs in the pet agreements, and nothing in fair housing requires periodic recertification. That admission guts their argument. Why? Because courts hate uncertainty. If tenants aren't placed on notice about a requirement, it's unfair to suddenly spring it on them years later. Imagine if the DMV demanded a random new driving test 5 years after issuing your license, without any rule stating they could. Chaos. Simpson is pressing for one thing: structure, and the absence of it is damning. For viewers, this demonstrates a key principle: rules must be predictable. Without policy, landlords risk accusations of discrimination or selective enforcement.
We
Or
notify them.
Or you can't do that, Mr. Weiss. She's under lease.
I understand. The pet agreement. I don't know. Pet agreement. There's nothing in the pet agreement that references it, but it also doesn't reference ESAs in a pet agreement. So ESA is a part of the fair housing.
Right.
Okay. There's nothing in the fair housing. I understand.
I'm trying to figure out what triggers the landlord to ask. And with that, what places the tenant on notice that the landlord can ask and then needs to comply with something?
Well, they have to inform us that they have a pet. Okay. If they're claiming that they have a need to have that pet classified as an ESA, emotional support animal, they have to go through the procedures as set forth.
Okay, but that's apples and oranges.
No, I don't think so.
Well, it is, because she's not here because she failed to notify you of the dog.
No, she's here because
She's here, at least what the landlord's saying is because the landlord made a request for the doctor to indicate that she needed an ESA.
the continued need.
And what gives the landlord the right to ask her that once she has already given it? Under what authority is the landlord requesting that?
Well, as I said, the ESA has no law either way. As far as
Either
required.
way, in terms of what?
Weiss admits something damning. The law is unclear. In courts, uncertainty is not a weapon, it's a weakness. If you can't point to a statute or rule, you're asking the judge to invent one. Judges rarely do that, especially in housing cases with Fair Housing Act implications. Simpson immediately seizes on this gap. Without clear authority, the landlord's actions look arbitrary. This is where the case tilts dramatically in Bell's favor. Think about it. Fair housing laws exist to prevent housing discrimination. If courts allowed landlords to demand random medical recertifications, tenants could be harassed endlessly. That's why unclear law actually strengthens the tenant's shield. Viewers, this is a great example of how silence in the law can work both ways. Here it protects Bell because courts lean toward tenant protections when ambiguity exists.
Of requiring recertification or not.
Here's the landlord's problem.
I know what the landlord's
Yeah.
problem is.
If the landlord said, okay, every year, for those that have an ESA, every year you must recertify the need. Fine. Even if then there's a late request, the landlord has something to say, I can make this request. So the time period doesn't necessarily matter. But as I'm looking at this from what I'm hearing is had the pit bull still been there, there would have been no request from the landlord to do anything.
Maybe.
Well, it's not a maybe. For the 3 years, 19, 20, 21, and 22, 4 years almost, that the pit bull is there, there's been only one request or one submission.
Simpson slices through the argument with cold precision for 3 straight years. Bell's pit bull was approved without challenge. No recertification, no questions. Then suddenly, when a new dog appears, the landlord wants fresh paperwork. That inconsistency screams selective enforcement. In law, patterns matter. If a landlord consistently requires something every year, tenants know the expectation. But when enforcement is sporadic, courts often view it as unfair or even discriminatory. Simpson isn't just nitpicking, he's laying groundwork for a broader ruling. If he sides with the landlord, it risks setting precedent that landlords can invent obligations on the fly. That's dangerous. Viewers, this is where the drama peaks. You can feel Simpson leaning toward protecting consistency and fairness.
They didn't ask each year.
No, but what?
There's not even anything, Mr. Weiss, unless you can point me to something that says, okay, periodically we will request X. Is there anything that says that would place the tenant on notice that the landlord could make the request?
Not that I am aware of right now, but if I can point the court before it makes a ruling, take a look at the email threads from Fair Housing and from Group 5 and Group 5's attorneys.
But what are those email threads going to do for me?
It would show that this was discussed. It was discussed with Ms. Bell.
Okay, I get it. I get all of that's discussed. And if necessary, I would take a look at it. What gives the landlord the right to do it in the first place? What gives the landlord the right to say anything that makes that discussion happen?
There's nothing that says that we can't ask.
Mr. Weiss, you can turn my question around all you want.
I know.
But it doesn't get you anywhere.
I used to be very good at that. You know that.
I know. And I expected that's what I'd get as an answer, but that's not an answer. I mean, here's the tenant who's saying, look, I have this ESA. I have this dog. Something happens with my dog. Let's say the dog didn't have to be removed from vet, but let's say the dog passes away. She gets a new dog. Would the landlord ask then for that? But they didn't, even in this case.
Not for a year later.
And then the question becomes, why did they ask a year later? Second thing is, under what authority did they ask that could affect this tenant's tenancy?
Well, as Mr. Herbeck had indicated, we didn't know about the dog, the Chihuahua, until long after she got it. It was seen.
Yeah, but you're not certifying the dog.
I understand that.
If I get if you were certifying the dog and it was the status of the dog that grants that authority or that position of the tenant, I get that then. But you're not doing that. You're not even, what you're doing is you're certifying, or essence, asking for certification from the tenant. So at what point, and obviously there is nothing in writing, at what point does that expire? At what point does the tenant, is the tenant obligated to do anything?
This is the knockout punch. Simpson points out the absurdity. If the law doesn't specify when a tenant must recertify, then logically the obligation never expires. He even uses a hypothetical about replacing a pit bull with a cow or a tiger to underline how ridiculous the landlord's approach is. The point? Without clear policy, landlords can't just move the goalposts. Courts fear arbitrary enforcement because it breeds discrimination. And Simpson sees the danger. If he ruled for the landlord here, it would open the floodgates for landlords to harass tenants with endless recertification demands. That's why he's leaning hard toward protecting tenant stability. Viewers notice his sharp tone. He's not just judging a case, he's warning landlords everywhere to get their policies straight before dragging tenants into court.
Let me pose an absurd situation.
Besides this one?
Yes.
Okay, go ahead.
Let's say the pit bull is removed and she decides to get a cow instead of a dog.
Okay.
Don't we have the right to question that as an ESA? Or do we? It's an absurd question. I can go hire an elephant or whatever. But we do have a right to review that situation.
I think you might have some justification if somebody had a dog and now has a cow. Or if they have a dog and then they get a tiger. I mean, I get that. But all I have, because at that point, though, your issue, the cow, and I'm not into answering hypotheticals, but your issue becomes that animal on our premises.
In part, yes.
Well, no, that's going to be, if it's a cow, I hope that's really your major concern.
Yes.
But in this case, it's a dog. And so it's not the issue of there being a dog. It's the issue of whether she needs an emotional support animal. But she's already answered the question, and the landlord doesn't have a procedure upon which they can make the request. Because the cold-hearted reality is, because of fair housing and other things, I'm telling you, Mr. Weiss, your client's going to be without a structure to it.
Without a what?
Without a structure to when they make the request or require the tenant to do something, they're placing themselves in a difficult position. Almost to the point, quite frankly, that I don't think you want to win this case because there's going to be a bigger fish for your client to fry.
With fair housing?
With the fair housing claim. Because nothing's here. Nothing the landlord is doing. First of all, does the landlord show me any contractual right exists for them to do?
Not that I am aware of. There's nothing in the pet agreement nor nothing in the lease.
The lease you have to register.
Yeah. In this situation, well,
But you're not,
That's
they
not
have
the
to
issue.
register the animal, but we're all in agreement that the animal isn't the issue.
in this situation, no.
Right. It's not the animal. It's her, it's whether or not she needs the emotional support animal. So, and then you're trying to charge her from back when?
October of 23.
Okay, so,
This case has been going on a long time.
but this case has only been going on since May for
Yeah.
me anyway. But I don't see it. I just don't. I mean, if somehow or another the landlord were able to say, oh, let me back that up. What really has happened in this tenancy is the tenant has brought forth documents that place her in a certain status.
Judge Simpson reframes the entire battle. He notes Miss Bell already established her status back in 2019 when she provided medical documentation. That status, her recognized need for an ESA, doesn't just vanish with the passing of years or the swapping of pets. Unless the landlord had clear policy requiring renewal, her legal standing remains. This is key because courts don't like shifting obligations after the fact. Once status is conferred, it sticks until properly revoked under the law. Simpson is signaling that Bell's rights were secured long ago, and the landlord's failure to establish renewal rules back then means they can't invent them now.
Right? Now, the landlord in that instance, as they have to do with many different things, has to have something in place that says if X happens, if there's a change in status, or that at some point periodically you have to renew with us the fact that you still get the benefit of that status. Or this is how you lose that status. But can you get it back? If the landlord had something in place that said, okay, you get this status, and it's clearly not the case here, but you get this status with this animal. Upon the removal, death, whatever of this animal, then you have to renew your status.
Well, doesn't that contradict what you just said?
Simpson plays out a hypothetical to expose the weakness in Weiss's argument. If the ESA status was tied to the animal, the landlord might have leverage when the animal is replaced. But here, the status was tied to the person, Miss Bell's medical need. That distinction changes everything. By reminding the court that certification is about the individual, Simpson undercuts the idea that a new dog automatically reopens the case. This is sharp legal reasoning because it separates the emotional drama of the dog bite from the actual rights in question. For viewers, it's a brilliant teaching moment. ESA law doesn't care about the specific pet as much as the person's ongoing need. The landlord's confusion between certifying an animal and certifying a person is what's sinking their case.
Pardon?
Doesn't that contradict what you just said?
No, I don't think it does. It only seems to contradict it because you're not really certifying the animal.
Exactly.
You're certifying the person. But those were hypothetical situations that I was giving just now,
Okay.
where the landlord could have certain things in place that then would require the tenant to do something, or require at that point, maybe even obligate the landlord to ask that you provide this information or whatever. But here, that's not what's happened. She gains whatever that status and the benefits of that status. There is nothing, I don't think, or nobody's shown me anything that changes that. That's the status she's in. The landlord then can't come along and say, oh, well, now you got to do this. Had the status, had everything attached to the pit bull, to the animal, as opposed to the tenant, then I get it, what the landlord's doing. Because now you have a new animal. Now I can ask about that animal. Not what happened here.
This is Simpson drawing a bold line. If the law required certifying the animal, then yes, swapping a pit bull for a chihuahua might trigger new paperwork. But since ESA law is about certifying the tenant's condition, the landlord's request collapses. That distinction is devastating for Weiss's argument. Simpson even suggests the landlord is opening themselves up to bigger risks, like fair housing violations, by pursuing this. Think about the irony. By trying to enforce a rule that doesn't exist, the landlord could end up in more legal trouble than if they just left it alone. For viewers, this moment shows why overreaching in court can backfire. Simpson's tone here is both skeptical and cautionary, making it clear he sees no solid ground for the landlord's position.
Can I ask a consideration? Whichever way you're going to rule, can you make it in a written opinion? Basing it on what you said in court today?
Well, I would.
In case my client wants to appeal it.
That's fine. I mean, I'll give an oral ruling. You can prepare whatever order you want. You can appeal away because the landlord doesn't have a status here. Or I could rule in favor of the landlord and then let you face the fair housing suit. Do it that way.
Another attorney has to worry about that.
But this issue,
No, I understand what you're saying.
somebody has, well, let me ask this then. Does the landlord have anything that forms the basis of their request to ask this tenant for that second doctor's note?
I'm not aware of it. Are you correct?
Well, as I said, she never did come forth to the office to register the animal. It wasn't until several months after she got rid of the pit bull and she was saw with this other dog. That's when we first made contact with her to register the animal. Here we are today.
Did she register the animal?
Never, no. She has not
But
registered.
the animal isn't the issue.
I understand, but she still hasn't complied with the pet agreement portion. So therefore,
Which portion?
she signed a pet addendum for the pit bull. When the pit bull was removed, she never re-registered the Chihuahua.
Well, you didn't ask her to register the Chihuahua.
Yeah. Well, we did,
No, you didn't. That's not what you asked.
not in this particular case, but
Yeah,
as a
not
side
in,
issue,
you didn't ask her to register the animal.
not for the ESA purposes, but she still has to comply with the lease, which
But if
requires.
that's what we were here for, Mr. Wise, fine, but that's not what we're here for. I
But
mean, I would absolutely agree with you with that previous scenario about the registering of the animal. But this issue is independent of the animal.
right.
By this stage, Simpson has completely separated the issues. He makes it plain. The case isn't about whether the Chihuahua was registered properly, or even whether Bell followed every pet addendum to the letter. The issue is whether the landlord had the authority to demand fresh ESA certification. This distinction is crucial because it stops the landlord from muddying the waters with side arguments about registration forms. Courts often narrow cases like this to avoid distraction. Simpson's sharp phrasing, "This issue is independent of the animal," slashes away the noise. For viewers, it's another reminder that legal battles hinge on framing. The side that controls the frame often wins. Here, Simpson has locked the frame on one point, authority, and the landlord has none.
But would we still have the issue if she registered the Chihuahua? Would she have to reclassify that as her ESA animal? That's one way of looking at it.
What did you ask her to do? But see,
We asked her to
hold on a second,
register.
hold on. No,
Okay.
because I'm not going to go down that path with you. Because what the landlord hasn't come in about the animal. That's not why we're here.
Well, yes and no.
No, because you're here because of her status.
Well, the case was originally started for non-payment of the pet fee and non-payment of the pet deposit. Was the basis of this particular lawsuit.
Right? But effectively, all of that was suspended in the best light for you, was suspended because she had an ESA. And was in need of an ESA. But then at some point, which just doesn't seem to fit into anything logical, she's asked to renew that status. And I think the problem here, even if you had a time period of every 4 years, are there other individuals that you treated differently regarding that ESA? That's the dangerous.
Simpson raises the specter of dangerous waters. If the landlord treated Bell differently from other tenants with ESAs, they're walking straight into a fair housing nightmare. Discrimination cases often turn not on what happened once, but on patterns of treatment. If Bell can show other tenants weren't asked to recertify, it strengthens her case for unfair treatment. Simpson warns Weiss bluntly, if he rules for the landlord, the case will likely bounce back on appeal with even sharper scrutiny. For viewers, this is where courtroom drama meets real-world stakes. Landlords don't just risk losing one case, they risk federal investigations or broader lawsuits. This is Simpson practically begging Weiss to reconsider whether pushing this fight is worth the fallout.
I knew you were getting to that.
Yeah, because that's the dangerous waters that your client is in right now. And that's what I was saying at the very beginning, because if I rule for your client, I have a feeling they'd appeal, it'd go up, that would come right back to me for a specific finding of was she treated differently? And then your client's got a whole lot of other problems, the least of which is an ESA on this property.
Okay, so basically, if I can paraphrase your thinking, Your Honor, you're dismissing this case.
I'm not. When Mr. Weiss, you know how I am. When I'm ready to do something, I'll tell you what I'm going to do. I don't know. I think as we've gone through this, I don't know that you need me to do it. The right thing to do would be for the plaintiff to dismiss it. And more importantly, then institute and formulate a policy by which you're going to handle these types of situations.
Simpson pivots from judgment to advice. He's practically giving the landlord a blueprint instead of pursuing shaky cases. Draft clear policies. If they want recertification, spell it out in writing from the start. Without that structure, every demand risks being arbitrary or discriminatory. This is Simpson protecting the integrity of the law while hinting at mercy. He's not eager to crush the landlord, but he refuses to reward sloppy practices. For viewers, it's a fascinating moment where the judge is both referee and teacher. He's shaping future conduct as much as ruling on the past. Think of it like a coach mid-game saying, "Here's why your playbook keeps failing."
Because and part of my reason for saying that is, even if I dismiss, I'm unclear as to this, but I don't know that alleviates the potential jeopardy for your client.
Well,
Under fair housing, because it becomes the issue of not always am I successful in what actions I take, that I'm taking certain actions that may be in violation of that and or discriminatory.
yeah, but if the court would dismiss it, or find no cause of action, let's say, and I would write an opinion, or not opinion, prepare an order to that effect, setting forth your reasonings for that. That would be could be a basis if my client wishes to appeal. That's all I'm asking.
Oh yeah, that's what they want to do.
Yeah.
No,
Obviously.
I don't really care, but
No, I understand.
I mean, I think there probably needs to be a discussion for you and your client as to where they're putting themselves.
That's a separate issue.
No, depending on what I do.
But if you dismiss it or find, no, this is a hearing on the merits. If you find no cause of action.
Well, but Mr. Weiss, I'm going to need to then take some testimony because there's going to be a question in my mind that I would have to resolve as to why this tenant why they made the request of this tenant. And I don't think you want my finding on that.
Can I have a brief recess with
Yeah.
my
Court will stand in recess.
Good morning. I had a chance to discuss this with my client. At this point in time, we will dismiss the case.
All right.
With one proviso, which doesn't have to be
Of
permitted.
course.
I requested that the dog be registered, not calling it an ESA or not, just that they have to go in the office and register the dog.
But upon registering her status,
It's not changed.
Okay. Ms. Bell? First of all, do you have any objection to the dismissal?
Providing they're gonna leave me alone.
Oh, I didn't ask you that. Do you have any objection to the
I don't
case
have any
being?
objection.
Okay, now, hold on, Miss Bell. You sat there so patiently before, you just wanted to yell at me, didn't you?
No.
All right. So then the next thing is that will you get the dog registered with them? That's not going to change your status, meaning everything's going to be like it is. They just want the dog registered, which probably is appropriate.
But Judge Simpson, we had actually given them a letter from Dr. McAvoy months ago
When I
stating
first got.
that the dog, that she's saying that he's supposed to have an emergency.
Hold on. I think that issue's over. Right? So
Well, he's asking me to send him an email from Dr. McAvoy.
I just want,
well, if you look, folks, they're looking to dismiss the case.
Mhm.
They didn't ask me anything about an email. The only thing that they're then asking is that you register the dog. And Miss Bell, you don't have a problem doing that, do you?
No, I can do that again.
Pardon?
I can do it again.
Did you already register the dog?
Yes.
we're not showing you.
You're not showing it registered, sir.
I checked it.
Oh,
Oh, okay. Well, whether you did it before or you have to do it,
I'll do
let's
it
get
again.
you'll get the dog registered.
Yes.
All right. Under those terms.
and the dismissal, Your
All right. Case
Your
dismissed.
Honor,
Yes, ma'am.
one thing, I just got out of hospital again, and this is my only transportation right here. Cause she's got to go back and forth to the doctor because she was in a car accident. So it's hard for me to get anywhere because I have to go on this. So could you just bear with me for a minute? Now, she said she's gonna try to email her or whatever.
Okay. You mean in terms of registering the dog?
Yeah,
Okay. Tell you what, get the dog registered the next 2 weeks.
okay,
Okay. Fair enough. All right.
Thank you, Your Honor.
thank you.
Thank
And just like that, the curtain falls. The landlord folds, dismissing the case with one minor condition. Belle must register her chihuahua. No ESA recertification, no back fees, no victory for the landlord's shaky arguments. Simpson has effectively shielded Belle from arbitrary demands while nudging the landlord toward clearer policies. This ending underscores the broader implications. Tenants with ESAs are protected unless landlords can point to clear, consistent rules. Without them, attempts to recertify can look like harassment or discrimination. For viewers, the lesson is simple. Legal authority must be explicit, not improvised. And Judge Simpson made sure that principle was front and center. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.